stand under Article 40 of the Constitution. When the magistrate hears the matter, the magistrate says, well, it's okay, I hold that there has been trespass, and that trespass amounts to a violation of Article 40. Matter goes to the Court of Appeal. The other person is dissatisfied. High Court, magistrate is upheld, says the magistrate is right, goes to the Court of Appeal. Court of Appeal says magistrate was right. The case comes to the Supreme Court, and the issue of jurisdiction arises. One party says the court has no jurisdiction. The other party says the court has jurisdiction. Where would you fall seated in that case? Of course, not disqualifying yourself, but where would you deal with the issue? How would you deal with the issue of jurisdiction of the Supreme Court?
Thank you, Honorable Commissioner. The Supreme Court has jurisdiction to hear appeals as of right where a matter of violation of the Constitution or of rights is involved. So that is already in black and white, and I wouldn't have an issue with that at all, especially if one is alleging violation of Article 40.
Mm-hmm. So in this particular case, you would be saying that merely because the person said it is trespass and therefore a violation of property rights, the court would have jurisdiction?
Honorable Commissioner, I am saying that if the purpose for appeal is based on the rights or violation of a right, then the court will have jurisdiction to hear it.
Mm. So in many instances where we interact with government bodies, there is a violation of a right, isn't it? Many instances, even when you are an employer, even when you are an employee, you've been wrongly terminated. It is a case for wrongful termination, and in your pleadings you say, I was wrongfully terminated, I need my damages, but it is also a violation of Article, is it 40? I think 41 or something, about my fair labor rights. Does that per se mean that it is a matter that will go up to the Supreme Court and the Supreme Court will accept that it is actually a matter of fundamental rights and freedoms?
Honorable Commissioner, just the fact of having been dismissed may not be a matter of rights. The right should have been pleaded right from the beginning. So, where from the initial pleadings, that violation of that or related rights is pleaded.
So, you are advising Kenyans that in every case you file, whether it's an accident, please plead a violation of a constitutional right, because the Supreme Court will take your case. Is that a fair assessment of what you're telling me?
Honorable Commissioner, I cannot be heard to be telling Kenyans that, because when Kenyans approach a court, they want an immediate resolution of their dispute, and the focus is finish with us now. They are not looking at the long trail of appeals. However, if parties are dissatisfied and they keep hopping from one court to the next, then the Supreme Court has jurisdiction only in certain instances. And where then one alleges a violation of a right, then that allegation should have been pleaded right from the beginning.
Thank you very much, Professor. Thank you, Chair.
Thank you very much, Honorable Judge Majaja. Thank you, Professor. I think I'll allow one more set of questions from Honorable Commissioner Macharia Jeru, and then we'll take a break. Honorable Macharia.
Okay, thank you, Prof. Let's proceed from where my colleague, Commissioner Majanja, has left. Owners of motor vessel Lillian S. versus Caltex Oil, 1989. Now, tell us what is famous about that decision, so that I can move now to my next set of questions.
Thank you, Honorable Commissioner. I think in that case, we only recite a very small part of it, attributed to the late Justice Nyarangi, namely that jurisdiction is everything.
Yes. Now, arising from that fact that jurisdiction is everything, there is a tendency sometimes of judges, when that issue is raised of jurisdiction, to say that yes, you raised it, but there are also other issues in your matter. Let's deal with all the issues, then I'll make one decision. Now, what is your position regarding that? And if you are a judge, how, if you are to be the Supreme Court, how would you deal with it?
Yes, very difficult question. I've seen those decisions. I think it's also a matter of judicial economy. I think the court would be saying, okay, you have raised this, but then you have also raised other issues over which we have jurisdiction. Why don't we handle all this in one, at once? There are other matters which are so clear-cut, or in which a court will clearly see that it has no jurisdiction, and there, as the late Justice Nyarangi advised, the court should lay down its tools.
Yeah, which is why I'm asking, if there are matters that are so clear the court has no jurisdiction, then why not deal with them and separate so that you're able now to argue the other issues? I'm just trying to understand now for you, if you are the Supreme Court and the issue of jurisdiction is raised. You are in the Supreme Court and now you're the President of the Supreme Court. So why would you want to combine all the arguments when you have an opportunity to separate, to sift? As it were, it's like sieving. So what would be your position regarding that, bearing in mind what the late Justice Nyarangi stated in that matter?
Honorable Commissioner, I will take a more strictest approach. If I notice that the court has no jurisdiction, we just lay down our tools.
But you've also provided for a scenario where it may have jurisdiction in some, it may not have in other issues. So how do you deal with that kind of scenario?
No, Honorable Commissioner, I was referring to what has happened before at the Supreme Court. If there's no jurisdiction, there's no jurisdiction, the matter stops there.
Okay. Now, let's leave there, and we move now to the issue of your CV, because I've also looked at it. It's quite extensive. Now, I noticed that you wear more or less two hats. There's the sports bit of it, physical education. There's the legal. Now, which one is your greatest strength in the two? Where have you been more vis-a-vis the other when you look backward into your career?
Honorable Commissioner, let's not talk about strength. You see, the computers we use have a CPU that famously stores information in specified files, folders, and so on. The human brain has files and folders that intermingle information. So I cannot say I'm stronger here or stronger there. They are not two separate. I'm able to mix the two comfortably.
No, I'm not doubting that. Prof.
Yeah.
You know, I'm using your words. You say that even when you deal with people,
Yeah.
when you've been in institutions, you look at their strength.
Yes.
That's what you said. So, you know, I'm picking now from there and now asking you the same question you ask others that you deal with. So, you have a lot of experience in physical education. You also have in law. So I'm pushing back the question now to you. Where is your strength when you consider the two?
Then I would want to answer it using the earlier version. Where have you spent more time? I have spent, I think, more time in the law part than in the physical education.
Now, because when I was looking at the universities that you've taught more, it seems like it's more on a physical education. When I try to extrapolate, vis-a-vis the law, there's nothing wrong with having both. I'm not disputing that. It's actually an added advantage, but I'm just trying to distill the information. So if we were to look at in terms of teachings, now from your scholarly work, it seems to me even the papers and everything, it's more on a physical education. Would I be right on that?
Honorable Commissioner, you would not be right in that, in the sense that looking at the papers, I followed the courses of studies in each of those disciplines from beginning to end. So, taking that approach, I'm eminently qualified in both. In terms of what you're asking about the teaching, I last taught physical education, strictly speaking, in 1998 when I was at the University of Namibia. Namibia, that was 1 year. Botswana, 2 years. I had been at Kenyatta University for 13 years. That makes 15 years.
15 years.
So I have spent about equal time in both areas.
Yeah, when did you start teaching law?
In 2010.
2010. So now, 2010 up to now, it's about 11.
Yeah, sorry, the teaching, yes, I was combining with the practice.
Okay. That's why I'm saying that the teaching, you've taught more physical education than the law. Now again, when it comes now to practice, I was looking at when you became an advocate, and you became an advocate. Now you're approaching, say, 16 years of
I think I'm approaching 17, not 16. I'm already done 16.
Yeah, 16, yes. So it's 16 now. So I was basically seeing again, it's like borderline because the qualification of a Supreme Court judge, Chief Justice, 15, right? So again, borderline. Now, bringing me to this question now. You see, and I'm not underestimating you are eminently qualified. I have absolutely no doubt about that. But you see, we have to compare, of course, also with the other candidates, because ultimately, when you pick that Chief Justice, we must account to the people of Kenya. This is not a position even us as JSC can just dish out as we wish. We must be able to account to the public. So now tell me, in comparison with the others who are also seeking the position, the same position, now, tell us what is it that you have that you think in comparison with the others puts you a notch higher than them in terms of bringing in transformation in this judiciary, both in terms of experience, in terms of vision. And you see, all this is the issue of a burden of proof. You prove by what you've done before, bearing in mind the fact that when people are being interviewed, they can say anything, but we look at their background, what they have in the past, that actually proves that going forward, yes, this is the person. So I don't know whether you could be able to distill that and tell us.
Yes. One of the things that I think I bring on the table very strongly is one of leadership. I have been manager for Special Olympics International in Church of Africa from 1999 December to 2001. In that role, I worked with very many sub-Saharan countries, oscillating between ministerial offices and the sports bodies in the individual countries, doing a lot of diplomacy. I have worked on a voluntary basis at the National Committee of Bioethics of NACOSTI for 6 years as vice chair. I want this commission to know that at the time I got to NACOSTI, about 2011, where the country was having certain challenges. For example, in 1992, a researcher from Kenyatta University, in collaboration with some from the UK, did research using materials from Lake Bogoria, extracted some extremophiles, the specialized enzymes for bleaching genes. The fellows out there went and patented, ran with it. All the bleached genes we see around here, the materials came from Lake Bogoria, but Kenyatta University got nothing out of that. When eventually it dawned on the university and it started making a little noise, the company equipped the biochemistry lab with computers. And it has now pledged to give 3 million shillings to the community and Roy's community around the lake. We lost out on that. Getting closer to now 2002, 2003, we had this challenge of HIV and AIDS. And one of the methods being propagated for preventing HIV and AIDS was male circumcision. Honorable Commissioners, in the process of pushing that agenda, somebody disappeared with 42 foreskins of Kenyans without their permission, without the knowledge of the government, without anything. While I'm still on, so arising from that, while at NACOSTI, we decided to address that problem, that challenge. And what did we do? We developed rules and guidelines for what we call material transfer agreements. So any researchers coming into the country and wanting to do research involving carrying out our materials, they must go through certain protocols so that as a country, we do not lose out. While at NACOSTI, Honorable Commissioners, we had a challenge with evaluation of ethical research projects. At the time, only Kenyatta National Hospital, KEMRI, and the Moi Teaching and Referral Hospitals had the capacity to clear ethical research. We developed rules for clearance of ethical projects. We developed rules for accrediting other institutions to put them in that position to clear research applications. And by the time I left, we had now set up about 30 what we call institutional ethics review committees. This means, in practical terms, that a researcher based in Mombasa doesn't have to travel to Nairobi to get ethical clearance. That can be done over there. Still on the question of while at NACOSTI, we worked on materials transfer agreements. That is a big relief to the country. We have expanded the manner of ethical review of research. That was a very big concern. And we have also kind of set out what is called operating manuals. So each committee knows what to follow in all standard operating procedures. So each committee knows exactly what to follow in the process of doing that. And we have made it quite easy for researchers. Honorable Commissioners, allow me also to mention something. In the 80s and 90s, for those who may remember, and even early 2000, if AFC Leopards was playing Gor Mahia at Nyayo City Stadium or Kasarani, the city center would be a no-go zone because of rioting and the mayhem that they usually left behind. From 2006, I became chair of the Kenya Premier League Disciplinary Committee, something I did for a number of years. And together with my colleagues on that committee, we agreed we were going to apply the rules fairly and strictly. I want to report here that we did punish those clubs fairly. The clubs realized that hooliganism does not help them. And with the support of the club leaders and so on, I can say we were able to change the culture. At the moment, even if AFC and Gor Mahia are playing at the stadium, people are able to go about their lives freely and without fear. Honorable Commissioners, that was a transformation. While we are still at that, when I became CEO of Kenya Football Federation, a post I held for a very short time, I found there a culture of corruption. Referees, each country is expected to nominate 20 people to participate internationally, meaning they are assigned duties in other countries, they get allowances, stay in 5-star hotels, very comfortable kind of thing, a very much envied thing. The practice then was that these referees were expected to bribe, number one, fellow officials, of referees officials, and then the bosses of KFF. I abolished that. And the practical way I did it was to just I would invite the officials of the referees, tell them, sit in that room, you have 2 hours, give me the list. As soon as I get the list, I forward it to Cairo. So I have that method to deal with corruption. Now,
try to, so that I can move to the next question, try to summarize. Please, you don't mind.
Yeah, I could just stop there so that we see if we can capture that in the
now,
next question.
You see, looking at all that, all of it is touching on sports, research, interlinked against sports and all that. We talked about Kenya Premier League, which you may or you may not be aware, I'm the one actually who registered it, set up all those rules, including that committee you're talking about, including even your appointment, and all those things. All of them sports related largely. Let's move to legal. So that, because see, what I'm trying to do is to match your skills with the job that you're seeking, considering that it's a high profile job. Let's go to legal, and you tell me now, as a practicing advocate, you give me 3 major cases that have had an impact on development of jurisprudence. 3 major cases, again very briefly, that have had impact on jurisprudence, so that we can trust that Professor Moni, we're not taking a specialist in physical education to the Supreme Court and become the Chief Justice. We're also taking somebody who has vast knowledge in a law and will be the leader of jurisprudence in that court.
Very well. The first one I want to point at, and which shaped the direction that other courts took, and therefore the jurisprudence, was the Odinga case of 2017. Having been decided within that stipulated time, now the other courts had no choice but to follow.
No, Prof. I'm saying a case that you have handled,
Oh, I have handled.
Professor, not
yes, sorry.
The case that Professor Moni Wekesa has handled that has had major impact on development of jurisprudence. You just give me three cases. Now that we've left the physical education, you've given a lot of achievement, and I agree. I have no doubt, I have no doubt you are an authority in sports, and that's why actually in Kenya Premier League, when you develop the rules, we chose you. I'm the secretary to date of the Kenya Premier League Limited, so I know why we chose you and not anybody else. Now I'm looking now for the legal strength, so that you can know, because we are not looking for a Chief Justice for physical education. It's also be a leader of jurisprudence. So you give me 3 cases that you've handled that have had a major impact on development of jurisprudence in the Republic of Kenya?
Thank you, Honorable Chair. Most of my cases have ended up at the High Court. I cannot really say they have had a major impact on the jurisprudence in Kenya.
Yeah. Now, okay, that's all right. I'll not pursue that point any further. Now, what I noted is that you've also had a stint on a political seat 3 times, actually 2007, 2013, and 2017. And 2007, I think it was Labour Party. 2013 was a United Democratic Party. 2017 as an independent. And I must congratulate you for giving it a try again and again. That's a mark of resilience, in my view. Now, but again, there's also a downside to it, because if you are moving from one party to the other, it may also mean that you don't have an ideology. And why I'm saying that, because then it means that you may also be lacking a philosophy that guides your thinking in terms of, when it comes to the legal jurisprudence. Because, see, if you look at all the judges, in fact, the famous judges that we even quote, say, for instance, like Lord Denning, you can see the flow of the thinking of Lord Denning, Now, if you are lacking in a philosophy that guides you, that could also be a danger. Now again, looking, as I said, this burden of proof, I'm looking at your past. So convince me that you have a legal philosophy. Tell me what it is and why you have, what guides that philosophy.
Very well. Let me start backwards. In terms of political parties, we live in this country and we know that we haven't yet matured politically to really talk about principles. We talk about congregations of willing partners. So it would be extremely harsh to be charged along those lines. Having said that, we have learned very many legal philosophies. My experience is that one applies a legal philosophy to a specific case depending on the facts and circumstances at that point. Generally speaking, I like the sociological school of law. The sociological school of law posits that one needs to understand the society for which the laws are being made. One needs to understand why the laws are being obeyed or disobeyed. One needs to understand the people in that society in order to be able to make appropriate laws. And in fact, here Eugene Ehrlich says, yes, if you want to know whether the Factories Act is working, don't look at the black letter of the word. Go to the factory, see how it is working. Now, with that philosophy, and remembering where I started, this is why I believe that so far, the judiciary has confined itself to a certain space. It has not moved to where the people are. And using that philosophy, I would want administratively to move the judiciary to where the people are, so that as they use the laws, as they partake of the judicial services, they are doing something that they can flow with. In terms of jurisprudence in court, all these laws, all these disputes that come will have a social bearing. When we talk about a case that has made an impact, we are talking about a case that has a significant impact on the society. And that's where now I say there are many schools I subscribe to.
Prof, with respect to what I've heard is more of political statements with generalities, not concise in terms of how your thought would flow, with tremendous respect. And, now, you mentioned something that just crossed my mind, where you say that our politics, there are no principles, there are all this, which means that you're explaining why, you hopped from one party to the other. But see, that concerns me, Professor, because, we are not looking for an ordinary thinker or somebody who flows with the, behavior of people in terms of how they conduct their politics. We are looking for this principled person who is able to provide a direction. This is the embodiment. This is the face of the judiciary. This is somebody who will be identified also with the development of the jurisprudence up there that could shape how the country moves. Now, if you are ordinary, just like the other guys who are fighting for those political seats and who are changing, as it were, depending on the circumstances you are saying. Now, how then can we trust you as our Chief Justice to provide clear direction based on sound principles?
This is how. Where I serve on the international tribunals, we apply the law and nothing but the law. In my academic writings, I've written about the law and nothing about the law. I am very focused. I am very, I can focus on the task and deal with the task at hand. I said it would be very unfair for me to be judged on account of what one is calling moving from one party to the other. However, even that movement from one party to the other has also taught me how to deal with politicians. And here, politicians are useful in availing resources to the judiciary, in helping the judiciary in other ways. I bring in that aspect. C.B. Madan, we adore him. Al Warren, we remember him. These were people who served in political offices at some point or other. I was not lucky to succeed in getting there, but I understand the mind of a politician, and I can engage them as CJ for the benefit of the judiciary.
Forgive me, Prof, if I give you an impression I'm condemning. I would never do that. I would not even judge you. It's just that, as I said, I'm trying to match the skills and the person vis-a-vis the position so that we can account to the people of Kenya. But I respect what you've done, and I acknowledge that. But which takes me now to the last thing that you said about how you've served in the tribunals, how you've applied the law, and all that. Kenya Rugby Union, of course you are aware about their complaint against which was served to you and which you responded to. But they are accusing you of not actually following the law. Because if you look at what they are saying, is that you are appointed to a Kenya anti-doping task force. And while serving in this task force where you are the chair, you went ahead and firstly never even give them an opportunity to be heard. The rules of, you breached the rules of natural justice, and did your investigations, and then named the coaches and players where you said that that were using banned substances. In fact, they're saying in their complaint that you went ahead and in some, and mentioning names of coaches of international repute in libelous fashion, that in pages 40 and 41 of your report, you stated that they were using food supplements, that were banned, that were contravening both World Rugby and KFU regulations, and basically saying that they were enhancing, what was banned before they were using, that was leading to them performing the way they were performing. And there was a hue and cry, the whole public, media, and all that. And you actually took You made spirited attempts to justify, and to continue, as it were, to rub salt in the wound, condemning them, alive to the fact, the fact that rugby sevens, it's one of those sports that have really catapulted, the name of Kenya in the global arena. But that notwithstanding, you still went ahead and did what you did without giving them an opportunity to be heard. Now, the World Now organization, when it came later and did now a very comprehensive, the World Rugby Anti-Doping Advisory Committee member, Mr. Gregor Nicholson, came, took 2 years, did a thorough job, and it was found that you are actually wrong, essentially vindicating them. But you can imagine now they are being vindicated after a lot of damage has been done. So I don't know what you would say about that, because that seems now to contradict what you just said about being in this international organization where, and bodies where you've been able to actually do very well in terms of proving that you can be fair, you can be just, you can be equitable, and all that. And remember, now you'll be going to be the Chief Justice, where you're expected actually to be an embodiment of fairness, application of rules of natural justice. I don't know what you would say about that.
Yeah, thank you, Honorable Commissioner. At the time I took over, I was appointed to the task force. A total of 34 Kenyans had tested positive for banned substances, including a rugby player, a football player, and so on. That is well documented in Appendix 1 of the report, which was submitted by Mr. Kankla, which I also submitted. In carrying out our investigations, we took a three-pronged approach. Number one, we contracted researchers from Kenyatta University to carry out an empirical research. They went out to rugby, to players, not just rugby, we're dealing with all sports. They recruited 1,500 in their sample. They used a questionnaire. Out of that, 1,365 returned failed questionnaires, giving it a 93% return quota. Of the 1,365, 226 were rugby players. There was then the question put to them: do you know anybody who uses prohibited substances? 78 of them said yes. It's in chapter 3. Then we went the question went further. Do you know what they use? And the answer was about 75% said yes, they use steroids. We were brought that report. So, and there were reports about others also. So specific now to rugby, we were told, yes, they use prohibited substances, they use steroids. That was one track. The other track is we conducted interviews. Number one, we invited all Kenyans to come and make presentations. And a number of rugby coaches came and made their presentations. I have furnished the commission with the detailed daily reports. We wrote to the chairman of Kenya Rugby Union on 16th of December, asking him to come and explain to us several things, including policy issues. As we did that, their official, the one in charge of programs, had appeared before us on 4th of December and told us the things they do there, including giving some things to players. We asked him, have you people tested those things? He said no. Do you know the ingredients? They said no. Then at that point, we took some samples for testing. Now, the other coaches came and also gave their narrations about the goings-on in the sport of rugby. They are all documented per date and per name. Having received, when the results came from the lab, and this was a University of Nairobi specialized drug analysis laboratory, it marked that all the samples that we had put in had tested positive. On 4th of March, we then, I think 6th of March, we wrote to the chairman of Kenya Rugby asking him to come before us. He did not come, but graciously he sent a team of 3 officials who appeared on the 17th of March. These 3 officials, one of them was a board member, the other one was a team doctor, the third one was the person in charge of logistics. They appeared before the task force. We discussed rugby. We gave them the results from the lab. We showed them. They looked at them. They were totally shocked. The results from the laboratory showed that the samples of the products that were being used had tested positive for steroids. So then, after that, we agreed to now get all the samples and keep them away for fear that these were going to harm our young, youthful players. So, at the point, up to that point, we had information from this empirical study of 226 rugby players. We had interviews with about 5 rugby coaches and officials who had given us information. We had this information from the laboratory, 3 different sources. We asked these officials, who is it that gives these things to our players? They gave us the names. We did not cook up those names from anywhere. So then in our recommendation, I think it's the last recommendation at page 37, we said, these persons should be subjected to a disciplinary process.
Okay, let's now be there. Let's hold on there. The people that you named specifically, names, did you summon them to hear their side of the story? The people that you specifically named in your report. Forget about, you are saying that you are told so and so are the ones who are responsible for distributing those substances. Now, those names that you are given, assuming you are right on that, did you summon those people now before putting their names in the report to hear their side of the story?
Now, specifically about summoning them, we were unable. Reason is, around December, the teams were out in Los Angeles playing. When we wanted them, we were told they are out of the country. Come the new year, they were on some tour in the Asian, Southeastern...
What were they doing, those tours?
They were playing rugby.
For which country?
I'm talking about the Kenyan team plus
exactly,
the coaches.
National duty.
Yeah, they were on that international trail.
Yeah.
We were unable to get them. Yeah. Our time as a task force was running out. So we recommended that they be subjected to a disciplinary process. And Honorable Commissioner, let me also add here that in terms of due process, and given our terms of reference, we were meant to identify any people we think have something to do with this bad image that was going on. Now, one can emphasize, allow me to finish. Okay. One can say they were on national duty. They had been on national duty all along, even when some of them tested positive. Track and field, they are always on national duty, but they test positive. And they out there, the world was complaining, you Kenyans, you are playing dirty.
You see, Prof, the point that I'm driving across, you'll be the Chief Justice there. You can imagine when you put on record somebody's name regarding an allegation, you know, you've already defamed them. You know the implications of that. And removing that record, that's a record that will always follow them. You know, so that's why, and it's the basic rules of natural justice. But we are not here to review the case, that matter, because that's not, our jurisdiction, so to speak. But
no, Honorable Commissioner, this is a very sensitive matter. The rugby people are looking at this, and I think it's also good to give me some latitude in time. Our task force report was eventually given to the World Anti-Doping Organization. It went through it. Then we had identified 3 case studies: athletics, FIFA, and World Rugby. It gave to those people under paragraph 3 of the Nicholson report, which I furnished. The author commissioned by World Rugby says, yes, they received this report on the 22nd of 22nd of October 2014 from the World Anti-Doping Agency with a request to follow up on the recommendations. Our main recommendation was subject them to a disciplinary process. From there, it was now up to World Rugby to verify whatever we had found and then see whether they need to be disciplined or not. And World Rugby did that.
in fact, you just preempted what I was going to come to, that the World Rugby's specific focus was whether there was any evidence to suggest that an anti-doping rule violation had occurred. And on March 10th, 2016, 2 years after your report, the Nicholson Committee, this is now the World Rugby one, cleared Kenya Rugby of all allegations. Isn't it? They cleared them completely. But you see now, clearing them, yes, but you'd already condemned them and had. That's the point that I was trying to indicate, that 2 years later they are cleared. But you can imagine the anguish they go through, which is now why I'm worried that if you became now the Chief Justice, because it's a quality about drawing conclusions, rushing to judgment without giving an opportunity to somebody to be heard. That's the point that I'm trying to address. Considering that this is going to be a Chief Justice, Professor Moni Wekesa. That's my worry. But as a last point on this issue, that we can close the matter. Now, at the time when you're doing that research or investigations, now the only accredited WADA laboratory in Kenya, in Africa, was only one, isn't it? The only accredited laboratory, WADA accredited laboratory. Where was it?
At the Free University in Bloemfontein.
Exactly. Now, so the sample that you used, which laboratory did you send them to?
Yes. The laboratory we sent them to is marked as under Appendix 6 of the report.
Which laboratory?
This is the Drug Research and Analysis Laboratory of the University of Nairobi School of Pharmacy.
Now,
I'm coming to that, Honorable Chair.
Yeah.
Sorry, Honorable Commissioner.
It's because the Chair has given us very specific time. That's why you can see I'm trying to rush you.
No, it's okay. Yeah. I've seen in the complaint somebody mentioning that lab. At the time we asked that lab, they told us they don't deal with foods. I have now furnished the commission with a printout from the website which says the laboratory only handles urine and blood samples. So even at that time, that laboratory was not available. I consulted. We have an Africa representative for water based in Cape Town. I consulted him. We checked with that lab. It said it could not handle. So we used preliminary results, and I think it's also good to point out that at paragraph 16.24 of the Nicholson report, they say that yes, the task force relied on the results of the Daru lab. We do not condemn anybody unheard. We collected information from several sources. I have furnished invitation letters that went out to the chair of rugby. The complaint there is that we never invited rugby to appear. Rugby appeared in a very big way.
All right, thank you. That's all, Honorable Chair.
Thank you.